Okay, so we're going to talk about the risk of judicial supremacy today. This is chapter 6 in basically sort of philosophy of law. We've covered many of the areas in the past that are underlying this, Montesquieu, etc., going back a few years now. So those who can remember should remember the separation of powers, etc. But today we're covering a very important issue. So the issue of judicial supremacy is one that strikes at the very core of what it means to live in a society that respects the sanctity of individual rights and principles of a rational, objective legal system. So at its essence, judicial supremacy is a notion that refers to how judges, through interpretations and rulings, possess the power to shape laws that govern society. So if we consider the implications of such a power in the hands of those who are not subject to the will of the people in a republic, democratic society, etc., those who do not bear the burden of public accountability, we don't vote for judges, we don't choose what happens. For instance, in the American Supreme Court, they're fairly much there for life. So it's a dangerous departure from the concept of a legal system grounded in protection of individual rights through laws created by elected representatives. If you remember, we've already covered the notion that judges are not meant to be creating law in the way that they're not an executive function. While they do shape law in interpretation, etc., there's a limit. And while the common law allows the law to shape around changes to society, it doesn't mean that you interpret for social outcomes. So in a society that claims to have and value freedom and reason, we need to now recognize that the power to create a law belongs to those who are chosen by the people. Not everywhere in the world, of course. If we go into many countries, this is still not the case. But in what we consider rational political systems, then those who can vote and create a system where the elected officials answer to the constituents can be scrutinized, challenged, and judged by the very public they serve. Conversely, judicial supremacy threatens to replace this system by rule of decree. Here, unelected judges, insulated from the pulse of the public, reshape society according to their own interpretation or whim. Right at the moment, as an example, Israel has moved a long way to this sort of state with judicial interpretation. And for a while, the US seemed to be moving that way. But a lot of changes have occurred, and the US has moved back towards a more rational, critical interpretation. So to ask, why is this important? And of course, we can ask and think about this because it's important because it strikes at the very heart of a Republican or democratic legitimacy. The legitimacy of any democratic system relies on, well, being able to analyze and interpret what happens to change our elected officials. So the ability of judges to interpret or reinterpret laws, to read into the meanings that align with their own subjective values, risks transforming the judiciary into a body that functions not as the interpreter of the law, but the creator. And that's the big distinction here in the common law. In the common law, judges interpret, they don't create law. So this is not merely a legal question. It's not merely jurisprudence. It's a moral question as well. It concerns the proper role of government, the nature of justice, and the protection of individual rights. And here we have a society that values these principles as one that cannot afford to ignore the dangers posed by overreach. We've covered overreach many times. And judicial supremacy, if unchecked, can erode the underlying foundations of our political and legal structures, turning the government of law into a government of men, arbitrary, unpredictable, and fundamentally unjust. Very different to what the system we're aiming to create is. So the urgency of this matter is one that I personally believe cannot be overstated. It's a question of whether we will continue to live under a system that is built on the respect of the rule of law, a system built on the rights of the individual, or whether we allow a select few to wield unchecked power, unaccountability. That's really what it comes down to. People who can remake the law according to their subjective judgment. And the US Supreme Court has gone through many instances of this where people have reinterpreted based on what they think society is, should be, etc., or the whims of society. But the thing to remember there is society has elected officials. These individuals set laws, not the justices. So, going further into this, judicial supremacy is something I consider an incredibly dangerous doctrine. It posits that the judiciary, specifically judges, become the ultimate authority in interpreting and shaping the law, even to the extent of altering the law itself. They integrate an executive function. That removes the aspects of the separation of powers that we discussed way back with Montesquieu. So it's the assertion that the judicial branch, rather than the legislative body elected by the people, holds the final say over what is lawful, permissible, and just in society. So in essence, it is the belief that the judiciary is not merely an interpreter of the law, but creator of law, a body that reshapes legal principles through the force of rulings. So we have a profound impact on our society because this touches the very balance of power underpinning freedom. The rise of a judicial supremacy is not just a legal technicality, it's a philosophical and moral shift, redefining the role of government. One of the areas I've also written about is bureaucracy. And when judiciary and bureaucracy exceed their powers, we have unelected officials becoming a quasi-oligarchy, really a 1984 or even more Huxley type version of society. So these interpretations that are imposed by the judiciary reflect the values, preferences, or ideology of the individual judge rather than an expression of the will of the people through elective representatives. So judicial supremacy, to finally define this, is a shift away from the very principle that law should be grounded in objective standards for the democratic process. It undermines the separation of powers, again, Montesquieu, a principle protecting our individual rights, one that the American founding fathers, Madison, etc., really fought to ensure that was implemented so that no single branch of government would wield unchecked authority. When judges assume the role of a legislator, they subvert the proper order of governance. They oppose their judgments in place of those that are determined by rational deliberation of the legislative process. It risks turning a nation of law into a nation ruled by the preferences of a few, undermining the concept of objective justice. Objectivity here is critical. So to really come down to what this gets to, the concept of judicial supremacy is something that undermines the core principles of freedom. So when we're thinking about this, I talk a lot about transparency and accountability. Judicial supremacy undermines both of these. A ruling from a judge might be meticulously argued, but it doesn't have the same moral weight as a law crafted and enacted through a democratic process. When judges impose and interpret the law in this manner, they bypass the mechanisms of debate, compromise, and public input. All of these are fundamental to a representative democracy. We may not like what happens. We may not like that we don't get what we want. But in a pluralistic society, then that aspect of forming a quorum, that aspect of forming consensus, is really what upholds the law and creates the rightful role of the legislature and the extension being the people in our society. So if we think about all of this for a moment, then what we're doing is replacing society with well, unelected officials. It's no longer either a republic or democracy. So judicial supremacy, well, it erodes democratic legitimacy, as I stated. So there's an incompatibility between the judicial supremacy doctrine and the principles of free democratic order. And, well, if we don't have the ability to have our elected representatives, well, represent us, then the very principle grounded in the belief that individuals with their own rational capacity who possess the right to shape the framework of laws in which they live is eroded. It's made no more. In a true democracy, it is the legislature, composed of those chosen by the people, that has the exclusive right to draft, debate, and enact laws. So just think about this for a moment. We sit there and we argue and we look at Parliament and we say, oh, what are they doing? They're just yelling and screaming at each other and they're debating. That's the function. Remember, this is taking the various arguments within society and making them real. Conversely, that has transparency. Judicial supremacy doesn't. So that corrodes the very fabric of society. Unelected judges, assuming the role of de facto legislature, then have power to interpret laws as they see fit subjectively. And subjective decisions, rather than objective ones, mean that we can't plan the future. We don't know what will happen. We don't know what someone had for lunch, for breakfast, how they feel, whether they've had a fight with their family, and how that will turn, well, the outcome to one way or the other. So judges can nullify, reimagine, or change legislative decisions when they have the right to interpret. They remove the lawmaking from the hands of those who are accountable. And we don't get to see the process. I don't know if any of you have sat in Parliament, watched, seen. It's not the most exciting thing. I've watched Question Time in for the British Parliament and also Australian, and it can be incredibly boring. That's part of the process. And the difference is that it's transparent. Whether you want to see it or not is a different issue, but you can. Conversely, a ruling handed down by a court overruling the intent of elected officials is not transparent. It's obscured. We don't see what happens. We don't also have a means of bypassing and getting into seeing what happened, but they can bypass the very channels of which representative government has occurred. So overall, this isn't just procedural. I emphasize again, I've said this already today, it's a moral issue. A judge ruling replaces law when we're interpreting things. It is suggesting that the few is superior to the collective wisdom of the electorate. It suggests that laws should be shaped by those who are shielded from public opinion, rather than those who face the consequences of their decisions at the ballot box. Again, this also comes down to bureaucracy. And of course, if we allow people to be voted out, if we allow people to, well, have to face the music, so to speak, then they're incentivized to act differently. Of course, we have to act ourselves by not voting, etc., and deciding we don't want to be part of things. Then we allow others to make that decision for us, and we can't really complain when it goes a different way than we like. So this shift elevates the subjective judgment of a few over the expressed will of the many. It's antithetical to the very concept of government by the people. So this creates what I would call an accountability deficit. Closely linked to the erosion of democratic legitimacy is the problem of accountability. We've mentioned that one many times as well. More accurately, the absence of accountability. This, going back to our little Bitcoin type topic, is my big problem with anonymity. Anonymity doesn't have accountability. It's not privacy. Privacy means that you're still, well, you're accountable for your actions. You have a way of being traced, etc. The judiciary, under the doctrine of judicial supremacy, wield immense power, but they don't have the corresponding responsibility that comes with that influence. They are not like legislatures who must stand before the electorate and justify decisions. They're not those people who stand there and argue a point, hoping to retain their positions. Judges remain insulated from the scrutiny of the public. And that lack of accountability is what creates a dangerous imbalance. Judges make decisions that reshape entire sort of swaths of public policy, and they do so without facing consequences. The decisions they make are not the same as those made by executive or legislature. If the ruling of a judge is out of step with the values and needs of society, but they interpret wrongly, the people cannot vote them out of office or hold them to account. There is no direct means for this. So this is a form of power that, if unchecked by the practical realities of public opinion, leaves people subject to decisions that they have no part in shaping. The consequence is that the judiciary can become detached. It can issue rulings that reflect not the needs or desires of the populace, but the philosophical or ideological leanings of the judges themselves. The accountability deficit means that we lack a corrected mechanism where the judiciary can be held accountable for overreach, where there is no recourse for a public whose rights or interests have been disregarded by the court's decree. The judge becomes a class apart, an elite, wielding power that is fundamentally unaccountable, standing in stark contrast to the very principles of republican government, where all power is derived from the consent of the governed. So the implications are the full erosion of the democratic legitimacy. It's removal of accountability, as I keep harping on. It's the, well, form of governance where laws are no longer a product of rational debate, as I noted above, and it's no longer something that is objective, stable, or accountable. So if we want to have a system that works, we need to make sure that we hold people within it to be accountable. So, as you'll see from all of this, it's not the longest chapter. I haven't finished it yet, but what it is a chapter that you'll find you need to think about. You insulate people from broader society and you change how they act. Who remembers Plato and the Ring of Gyges? We do. Why? Who wants to tell me what old sort of Ring of Gyges does?
It gives him power to be invisible,
Mm-hmm.
and essentially giving him that power ends up corrupting him. I think I don't remember exactly how the story goes. I believe he works for one of the powerful Greek landowners or something, and when he gets the power to be invisible, ends up, I don't know, using it to take over,
Rape, theft,
the whole.
murder. Exactly. And we see this in many stories. This isn't an isolated one. If we think Lord of the Rings, what happens? Well, Ring of Invisibility, effectively. On top of that, we have, well, the Invisible Man. And if you've ever read the story of the Invisible Man, not the modern comedy version, but the original sort of Wells version of the story, you see a man who becomes a monster because he's invisible. He loses accountability. So once we lose accountability, we don't think about why we're doing our actions in the same way. When we have to think, well, what if people see me doing this? If people know, we will act differently. Whether you consider that's good or bad for you, you will act differently. When someone is watching you, or you know that there is an audit trail, even if you're not being watched, you're going to act differently. And when a, well, lawmaking body is held accountable, it needs to be able to be viewed. If we think about the what happens behind the scenes sort of analysis of many totalitarian governments, the problem isn't that laws are being made. The problem is that laws are being made without any direct input. So the foundation of self-governance requires that laws must be, well, able to be analyzed, crafted, enacted by chosen representatives of the people. That's how we ensure that we actually create democratic legitimacy. And without that, we're never going to have it. So the notion that those who create the laws are directly accountable to the citizens who live under them is really the foundation of what we consider a, well, Western rational society. It's not a system that has been, well, most of the world or most of history, but it is one that we have built up and implemented over time. One that if we don't protect, we'll lose. And judicial supremacy disrupts that fundamental principle by allowing judges unelected and removed from public accountability to reshape law. Then remember, we create an alternative legislature, an alternative replacement for the electorate. That ability to reinterpret or strike down laws means that the judiciary can supersede the legislative process, superseding its will for that of the people beneath it. And that means that there's power that can be wielded without the obligation to represent those who are the elected. So again, accountability deficit. It's the same difference in why, well, Bitcoin will never really become a global system unless it maintains traceability.
Can I
People
just
don't. Yeah, please.
I just put in that I'll just go to hand up, but I just want to make a comparison point. It makes me think of the BTC devs trying to create their own, make themselves God kings. When a judge starts creating their own rules and laws, interpretation, and shaping their own laws, it's like, wait a second, no, there's a system in play. Stop trying to go off on your own and create new laws. And over to Archie.
Please.
Yeah, I don't really have any good references, but I always kind of made the assumption that the reason the judges were appointed and don't have term limits was because the majority can also be irrational. So I could kind of assume that the founders thought, well, okay, we want to slow down lawmaking, is why they do electoral colleges, take a super majority to do things. And then also they just don't want an irrational population electing at least one branch unelected, and then instead of mob mentality, if they followed the common law stare decisis, they would have the wisdom of the masses of the majority over time. But there's still no way of ensuring that judges are objective and not subjective. But what do you have any thoughts on hey, what if why they did that, and how you counter
Yes.
an irrational
So again,
masses?
we go back to old Montesquieu there, reflecting the Roman implementation of a balance between, well, different levels of society, between wealth and power and generally the people, and trying to balance all of this. And the judiciary's role here is very conservative, and it is to slow down change. By not being able to just jump in there and decide for others, it also means that they can effectively hold the will of the past. Now, many people think that, well, the will of the past doesn't matter, but of course it does. It represents the will of people who set up a system. And change for change's sake is in itself a problem. We're not going to actually, just by experimenting and trying everything, find solutions. It creates chaos and uncertainty. And while to many, especially those in the left, it might seem, well, we need to do something. Well, actually sitting and analyzing is still doing something. Just throwing everything out to try something new isn't what you would call the best way of doing things. So the judiciary has a role as well of making sure that the minority is protected. So just because the majority, a democratic mob, well, decide something, the role of the judiciary is really also to ensure that accountability is held across society and that the rights of the minority, the individual being the ultimate minority, are upheld. And if we think about it, the very limit of minority is always the individual, the person. And in an individualistic, non-collectivist society, then we're always going to end up, well, wanting to make sure that the property rights, the rights of the individual are protected. And that is one of the key roles of, well, what a judiciary should be doing. So as we go over this, if we start thinking about it, the judge who now takes the interpretation of the law, striking of the law, etc., into their own hands based on what they believe is the will of society, is also undermining the very principle of minority protection, of accountability, of sitting there going, society wants this. You're forgetting that, what about the individuals in that society? And Margaret Thatcher, to badly paraphrase, said, there's no such thing as society. What she meant by that, even though people mock some of that, especially those who are a little bit more socialist in nature, what she meant is that at the end of the day, there's no collective will. There is a bunch of individuals, all with competing interests. Unless you're talking about people in BTC core, and they seem to just do whatever they're told. But that's mocking them. So getting back to what we're actually talking about, the question of legitimacy and accountability isn't the only problem. If we think about why we have, well, basically a bunch of people locked in a room, why we have things like filibusters in America, then it's a process of vigorous discussion. And it's not how quickly can we get a law enacted. It's not we have 51% of the people, we have to drive this through and make the change no matter what. It's about negotiation, compromise, that different perspectives are heard, even minorities. It's sometimes forming consensus between small groups. Unfortunately, some of the smaller groups are getting far better than they should at this. Some of the green groups, for instance, they're using this ability to basically tack on and make deals, which in a way is actually their right. But unfortunately, the majorities aren't always as good at this as they should be. So going back to what we have a controversial legal issue, one that, well, removes legislative debate and, like everything else here, removes this ability to, well, analyze, to talk, to discuss. In recent time, in the US, for instance, there's been a lot of kickback because one previous case, Roe versus Wade, 1973, the United States Supreme Court established a nationwide right to abortion. Now, regardless of your views of the outcome, the decision represented a dramatic instance of the court inserting itself into the debate that was a debate that was intensely political and one that could be decided through the democratic process in each state. Instead, the court's ruling circumvented state legislatures, preempting a national debate that was only beginning to unfold and replacing it with the decision of a group of men. The result was a deep, enduring divide in American society, with many citizens feeling that the decision lacked legitimacy because it came from the bench rather than that of the ballot box. And you can complain all you want, going, the rights of women are X. But the way I look at it is there are 50-something states in America. And if you want to, well, live in a state that supports abortion rights, that's your right. No one's stopping you from moving. And if you want to rally against it, then go for it, etc. Both sides. There are choices to be made by people. And the same in the United Kingdom. So if we have a look at R. Miller versus the Prime Minister 2019, the Supreme Court in the UK ruled that the Prime Minister's prorogation of Parliament was unlawful. This case involved a highly contentious political context, with the court stepping into the realm of political decision-making that really should have been resolved by the parliamentary process itself. The whip, the Speaker of the House, etc., have roles. So while the court was justified in its intervention as a defense of constitutional principles, it could also be argued to be an encroachment into a domain traditionally reserved for elected officials. That underscores the growing role of courts in political questions. And we see that raising questions about the boundaries between law and politics. If we take another example, in the Indian Supreme Court, Navchev Singh Jahar versus Union of India 2018. This case decriminalized same-sex relations. Now, this is an example of judicial activism. Whether you agree or disagree with, well, same-sex marriage is not the point here. The decision was lauded for advancing human rights. It was a clear instance where the judiciary took upon itself the role of reshaping social norms. But this bypassed the legislature in a country where debates about culture and tradition are politically charged. So rather than allowing the issue to be addressed through the Indian democratic process, the institutions that are there, the judiciary subsumed the role and assumed the decisive role in setting the matter that they chose. Sitting there and going, well, the world needs to move on, isn't the role of the judiciary, whether we think that is right or not. So these examples that I've now given you demonstrate how far-reaching the implications of judicial activism can go. They illustrate that courts, through their rulings, redefine social policy. They alter the legal landscape and change the course of political debate, all without the direct consensus of the governed. When the judiciary moves beyond its role as an interpreter and becomes a maker of law, it transforms its role into a fundamentally different position, one more powerful and less tethered to any oversight. So we're getting beyond the role of elected officials, for instance, now, and we're replacing them with some of them we can't actually get rid of. So if you remember, we have already covered aspects of natural law, and whether you believe natural law is secular or from God, that's a different debate. But as humans, we have a view, and there are general things that throughout most societies are fundamentally the same. Murder, theft, etc. rarely change. They're generally abhorred in most societies. Now, legal positivism has a critique of judicial lawmaking as well. Legal positivism stands in direct opposition to the idea that judges should create law through their rulings. It offers a fundamental critique of the very concept of judicial lawmaking. The heart of legal positivism is the belief that a law is a construct of human design, a set of rules created and enacted through the authority of a legitimate political body. the legislature. This emphasizes separation of law and morality, arguing that legitimacy of law comes not from its ethical content, but from its formal source, the origins, the legislative process. I, of course, I'm not a legal positive, but I think I've made that one clear. I'm natural law theorist myself, and both of these object to this role. But the role of judges in positivist views is not to question the moral soundness of the law, but to apply it as it has been written and enacted by the appropriate legislative authority. Judges are meant to interpret the letter of the law, not its spirit. They should impose their subjective values only on in their own mind. They shouldn't take them into the sort of judgment. And judicial lawmaking is a distortion in this view of the role of the judiciary, elevating judges above the law itself. And that, of course, is a problem. The law should be above everyone. So legal positivism critiques judicial supremacy, arguing that it undermines the objectivity and predictability that the rule of law is meant to ensure. When judges reinterpret laws or create new legal standards through their rulings, they introduce a level of uncertainty that disrupts the stability of the legal system. The law ceases to be a fixed framework and one that is able to be predicted into one which individuals plan their actions on a shifting, chaotic landscape. It becomes vulnerable to interpretation and preferences, and it becomes subjective. So judicial lawmaking is seen by the positive as a betrayal of the principles of a government that are bound by laws rather than the whims of an individual. It doesn't matter how well-intentioned anyone sort of might be. I mean, it's the old, the road to hell is paved with argument. So for a positivist, judicial lawmaking goes beyond sort of the pale and undermines the safeguard of justice, becoming a violation of the democratic process. It is an affront to the very sovereignty of the people and society. To a positivist, the judicial supremacy undermines the elected representatives and the rightful creators of laws. It has judges step beyond their role and become an instrument of, well, unpredictability, undermining the rational legal system, transforming it into a tool of subjective adjudication. So, natural law perspective, moral responsibilities and the danger of moral authoritarianism. This is one of the areas that I'm more aligned to. Natural law, by contrast, provides a different but equally critical perspective of the dangers of judicial supremacy. In this, we see that, well, the necessity of morally reasoning through something, moral reasoning of law warns against dangers of moral authoritarianism. We can't just imply that our morals, our subjective views, are beyond anyone else's. This is rooted in the belief that the law must align with universal moral principles. Natural law theory insists that laws cannot be considered legitimate if they are inherently unjust. The true law, from this perspective, is not merely a set of human commands, but a reflection of moral truths transcending any particular society or political system. And many of the foundations of what you see in the founding fathers of the US come from this perspective. It's then putting an underlying constitution, an underlying set of values that society will hold dear. And from this standpoint, from the standpoint of natural law, judges do have a moral responsibility, but it's one that requires them to consider whether the laws they interpret and enforce align with the higher principles of justice, fairness, and human dignity or not. A judge in this view is more than a mechanical enforcer of statutes. They are a steward, a custodian of moral order, and they inform the proper application of the law, not subjectively and not just by their own view, but, well, from some higher view. The perspective grants judges a broader interpretive role, but it allows them to do this in a way that reflects not just the words of the statute, but the moral imperatives sort of set by society. So in the US, that written constitution becomes paramount. Why did it form? What was the intention there? And that doesn't mean reinterpreting. It means, well, understanding. So natural law cautions against allowing judges to become arbiters of moral truth. Such power can easily transform into a moral authoritarianism. And when judges impose their interpretation of morality into the legal system, they risk concentrating too much authority in themselves. This, again, overrides the sort of mass of society, the moral judgments of a community, the underlying aspects of what makes a society strong. The judge who substitutes their personal subjective convictions for the laws created through a democratic process becomes a moral legislature, a role that belongs not to the judiciary, but to the elected representatives. So that's one of the key aspects here. Natural law theory acknowledges the tension. While judges should ensure that laws do not violate the fundamental moral principles underlying what made a society, they must also be wary of overstepping the bounds and assuming the role. It's that accountability, once again, the role that eclipses the democratic process should be banned. It emphasizes in this, well, natural law theory requires balance, recognizing that laws, well, must be just, but the judges need to respect the mechanisms through which society determines those laws. And it doesn't mean that they agree with society. A judge who ignores the balance becomes a despot in the name of justice. They wield moral authority of the bench to dictate rather than interpret. So if we contrast these two different viewpoints, what we find is legal positivism and natural law offer sharply different and contrasting visions of the judiciary's proper role. Each has a profound implication on how judicial power should be exercised. Legal positivism demands strict adherence to the written law. It emphasizes the importance of legislative supremacy and the need for consistency in judicial interpretation. Its primary fear is the descent into a formal judicial tyranny, where judges who are untethered from the clear mandates of statutory law create uncertainty and undermine the democratic process. The positivist perspective is one that would curb judicial creativity in favor of a more rigid, predictable system of law that derives its legitimacy solely from its formal source. The distinction here is, I find that as a natural law theorist, that also undermines many of the functions of common law. It doesn't allow the law to grow and change. The law shouldn't just change, it should grow and change with society slowly. It shouldn't advance ahead. It should follow what society does. That's the distinction between an activist judge who takes the lead and one that waits and lets the judiciary rule and then chooses based on what may or may not be right. Natural law accepts that there is a higher standard to which all laws must be held. Here, judges have a duty to ensure that this standard is respected. In America, you have the written constitution, you have the Bill of Rights, you have documents that grant judges a more active role in the moral dimensions of law, but within bounds. It is a way of arguing that the judiciary must not enforce statutes that run contrary to universal principles of justice. So in this perspective, we, of course, have the danger of judges using a broad role as justification to impose their own moral frameworks that can bypass a democratic process in what they consider to be a higher truth. The implications of contrasting these two viewpoints, positivism and natural law, are clear. A legal positivist framework has a restrained judiciary. They serve as a stabilizing force within the judicial system, ensuring that laws remain consistent and predictable. That's important. It offers an important legal order that respects sovereignty and that of the legislative body, avoiding the imposition of personal philosophical views from the bench. Natural law, in contrast, envisions a judiciary that is a guardian of justice within bounds. it is willing to stand against unjust laws when necessary. But the important area is making sure that there is accountability and feedback. So this comes into the level of justice. As we go through the courts, when we go from the lower benches to the high courts to Supreme Courts, etc., then there should be less role of activism. The higher the court is, the less it should be taking a lead in changing society. And we must remember that it is critical that that fine line between applying universal moral principles and respecting the democratic choices of the society in which they serve matters. So when we're looking at all this, we need to think about how we manage this and build it, well, in our society. How do we ensure that all of this is correctly balanced? And that's up to us as citizens to explore. This is where I harp on about education. While it's critical that we have people in society who are trained, who know how to do math, who know science, who know various different skills, that's not education. Education is going to start with civic duty, understanding why we do these things in our society. So key judicial decisions here, we already mentioned Woe versus Wright. So I'll skip over that. Most people understand that one quite well. They've seen a lot of it. The right for privacy was, well, defined under the 14th Amendment and reinterpreted that way. And that deep and lasting divide that came from that still causes problems even today. So Obergefell versus Hodges, well, there we see the Supreme Court of the US legalizing same-sex marriage. That was a 2015 case. The thing is, it made it across all 50 states of the United States. So those supporting LGBTQ plus whatever now rights, well, argued that this ensured marriage should not be denied on the basis of sexual orientation. However, like Roe, it bypassed the legislative executive process in many states where debates and public opinions on the issue varied widely. Instead of allowing each state to reflect its populist views on their own laws that they put, the court mandated a single standard for all. And that can be a problem. You should know by now I'm all in favor of competition. And I like the fact in the US that you have 50 competing states. I'm very much, even though I'm not American, a states' right type person. The principle here is you can move. I've done it many times. Even when I didn't have a lot of money, I've managed to do it. People without money travel, move, etc. It can be done. You have that choice. So Obergefell created, well, division because the judiciary decided for people rather than educating, changing people's ideas, rather than forcing that on. It was forced on people. So we mentioned as well in the UK courts, Miller versus Prime Minister. And that again is judicial activism. Boris Johnson's advice to the Queen to prorogue Parliament during Brexit negotiations was unlawful. The court's intervention was seen as many as an effort to preserve parliamentary sovereignty and uphold constitutional norms. But equally, it could be criticized as an intrusion into political domains governed by elected officials. So, thinking further, the impact on these decisions changes public trust. If we look at Roe versus Wade, it has now caused 50 years worth of division that didn't need to be there. It might have simplified the lives of a number of activists, but all it's done is created division that is still not solved. So rather than debates, we've created less trust in our government. We've undermined the very fabric. So what I would actually propose instead is improved legislative drafting and enhanced judicial accountability. So the dangers of supremacy in the judiciary are only done by exploring solutions that reinforce the balance between judiciary and legislature. It means accountability. So we need a process of regular review and revision. We need transparency. And in tandem with better legislative drafting, no allowing tacking on things at the last minute, etc., as seems to be common these days, then judicial accountability must be done in a way that doesn't undermine judicial independence. We must still have a fair and impartial judiciary, but rather than implementing mechanisms that ensure that judges are mindful of their role, sort of out of any feedback, they need to have some way of establishing regular reviews of judicial performance. That doesn't need to be we sit there and vote for them. I don't agree with that. But there needs to be some sort of performance review, even from their peers, to ensure that the standards of interpretation and respect for boundaries are upheld. So judicial councils are one way of doing this. A judicial council can serve as a valuable tool in maintaining a balance between judicial independence and accountability by creating a body composed of legal experts, representatives from various branches of governments, ones who can oversee, appoint, and conduct evaluations and address the issues of judicial misconduct. In this, by performing a forum for assembling judicial decisions and conduct, a judicial council can help ensure that judges maintain a neutral view aligned with their proper role as interpreters rather than creators of law. Again, judicial councils, if we had them properly implemented, would offer a mechanism for the public input on the judiciary. It would allow concerns about judiciary and judicial overreach to be addressed without compromising independence of the courts. It can create a space for dialogue between the judiciary and other branches of the government. It can then foster deeper understanding and the proper boundaries between interpretation and lawmaking. And one of the critical areas here, it builds trust. When we have people integrating into all of this, then it's a safeguard on how society works. And by doing this, we have feedback. People can interact with the judiciary and they can see what's happening. And that transparency creates a balance that preserves the legal system and, well, the consent of the governed and their role in the rule of law. So that's really the concept of what this section's about. Questions?
I'm just going to quickly address the Twitter space. Twitter space, if you have any questions, we have around 36, 37 people listening at the moment. It's been a steady 30 plus. So it's actually, technically, it's been the largest class we've had. So we're going to continue doing these sound bites through Twitter space in the following months, as the idea is to spread knowledge and to teach as many people as possible, that you can then further teach other people. Don't, ideally listen, soak it all up, but ideally teach other people and tell other people about what you've learned. And if you have any questions from Twitter, which I will go to in a bit, then please type your question and tag my name. But we will have priority on questions to the class in attendance. So over to Archie.
Yeah, I was gonna ask a question tied into Bitcoin. Bitcoin as a system, compare it to legal systems. Would the Bitcoin white paper be considered like a posit, kind of the way? And then I guess I don't know if I need to look at that word in positivism more. But another question that I've been wondering for a long time, I think one of the most interesting parts of the paper is the first two words of section 6 is by convention, and then it goes into the assigning the roles of, obviously doesn't use the word minors right there, but would that be similar to, like, Locke saying, and what you've been saying, hey, people have the choice to move, and hey, if you don't like it, you can change states or go somewhere else. Or Locke's, saying, and the founder saying, hey, the powers are derived from the consent of of those governed. So
Mm-hmm.
is this idea by convention, the way it starts, the same idea there? Like, hey, if you don't like the system, then go to another one. And then just
In
that
part,
word
yes.
convention itself is interesting.
The foundational principles of Bitcoin in the white paper would be equivalent to the Constitution of the US. While there is some room for arguing what it means, then there are some things that are pretty hard to argue around. When you talk about things like small casual transactions, you can't say that a transaction that can cost $50 to send is anything related to a small casual transaction ever. You can't say that a system that is designed for electronic cash is, well, digital gold that should be never moved and hoodled. So there are ways that you can debate. What do you consider a small casual transaction? Is it $1? Is it 1 cent? And people can debate that. But you can't get away from the fact that it is effectively digital cash. And those boundaries have limits. And nobody in their right mind is going to be sitting there going, oh, well, I think being able to send $100 million transaction around the world for only $50 to $100 is a small casual transaction. I don't think that would even be Jeff Bezos's idea of a small casual transaction.
I think even before that, I mean, the very first people say the small casual transaction, but the very first sentence in the introduction refines it even more than later on when it says small. It says it starts with commerce on the internet. So if it can't do commerce on the internet, and then it talks about third parties, which right there you can look at the cost of third party settlement on the internet today, and if it's not lower than that, then it's obviously not doing what was defined in the paper that defines it.
Yep. And I mean, it still suffers from the inherent weaknesses of the trust-based model. And what we're really doing here is we're not going, oh, we have to throw away all trust. We're saying that the trust-based model has weaknesses. And by creating this new system, we remove and mitigate some of those weaknesses. So it doesn't say that all transactions in Bitcoin will be completely non-reversible. It says at the present time, completely non-reversible transactions are not really possible since financial institutions cannot avoid mediating disputes. Now, what that means is not that, oh, Bitcoin must always, in all instances, be completely non-reversible. Even by consent, it becomes possible to set up escrow transactions or even payment channels where it is reversible. What it does mean, however, is, well, they are possible. They're definitely going to be feasible in small amounts. There's no reversibility in a coffee transaction. Nobody in their right mind, and for that matter, no judge in their right mind would ever accept someone going, well, I bought this coffee in Starbucks and I didn't like my grand pumpkin, whatever the hell, stupid, ridiculous latte, and I want my £6.50 back because, well, no one should ever put pumpkin in coffee. It's just wrong, morally, really wrong. And it's not going to be reversible. The company might give the money back to you, but the transaction itself isn't ever going to be reversible no matter what. And the simple fact of the matter is that's different to then going, oh, well, I just accidentally sent $1 billion off to the wrong people and screwed up everyone's pension. Maybe I should leave it sitting there untouched. So we have to actually still think about these things. And the Constitution, well, has room for interpretation, but within limits. And same with the Bitcoin white paper. So the cost of mediation increases transaction costs, limiting the minimum practical transaction size. Well, that's an important aspect. What we're saying is the minimum size is limited. And with Bitcoin, we can reduce that size. But what we reduce it for is another question. So the same with going back to the judiciary. We have a limit of what we can do. We have the differences between the positivists and the legal, like natural right theorists like me, and others who believe in judicial activism. And there needs to be a balance. And it's really what it comes down to. So,
Right. I have a quick statement and then a question from Twitter. Just wanted to add to like what you were saying about don't do coffee reversals because it's daft. But it's really easy on Bitcoin to do a refund when you just
yes,
ask or
but
like
that's different to a reversal.
yeah, absolutely. But
So you can easily refund someone's money,
compared to
but you have
compared to like if you brought a cup of coffee, then I would need to ask your bank details to give you back.
yeah.
It's a lot easier. So the question from Twitter, which you have actually mostly answered already, but I'm going to ask the question anyway. Root 117. In relation to Bitcoin, is it true that the white paper is equivalent to the equivalent as the Constitution, principles that can't be changed? Then we enforce law through objectivism, while the general masses form consensus to build around the systems? Question mark.
Well, you can, I mean, it is the Constitution, but that also doesn't stop you building a lot of other things. Bitcoin was formulated with a number of opcodes, and many of those can be used and abused in ways that I never thought possible to be, or no one looking at any of it would think possible. But the reality here is you can, but that doesn't mean it's right or wrong, and it's not for me to choose. If, for instance, something in the ability of, well, creating a script is within the realm of what an opcode allows, then, well, it might get mined, it might not. Again, it's going to be a balance between what you have and haven't created. But at the end of the day, that's very different to forming a system, well, timestamp server, small casual transactions, etc. If I made a Pinocchio type sort of, well, circuit and make a 4 terabyte transaction, theoretically, it might be possible that some miner in the future might mine it, but it might also be ridiculously expensive. So again, just because I do it doesn't mean it's going to happen. But going back to the original question, yes, it's fairly much a constitutional process. And the Constitution is set there to limit what can occur. And the distinction is you don't actually vote on the protocol in Bitcoin. There isn't any voting process because there's no democratic process. People owning Bitcoin don't get a say. It's not how it works. One problem with that, if it was, you end up with like proof of stake, where it becomes an oligarchy. If you get 51%, you do whatever you want. So I'm actually going to have to run in a moment. So if there's any last questions, I'll answer those before I have to run.
Last question from Christopher then.
Yeah, I mean, the subheading in this chapter, the accountability deficit. I feel like that's something that, I mean, my own personal experience participating in the Cummer lawsuit in Canada. I'm not sure how familiar you are with that. It was something where we tried to get the government of Canada to reinstitute the Bank of Canada to its original mandate. And it came at a time when the government was actually trying to institute a infrastructure bank. But when our lawsuit was thrown out, they pretty much washed their hands of it. The Supreme Court of Canada washed their hands of it and said that it was a political matter, but it was sort of a conflict of interest, in my opinion, for them to hand it to the politicians again, who were at that time trying to institute this infrastructure bank. So I've kind of thought about this for a for much of the last 10 years, how we can kind of avoid these kind of things from happening. And I really see blockchain as a solution to that, Bitcoin as a solution to that. And I mean, one of the things with the need for clearer legislation and drafting legislation so that it's actually understandable to the average person.
I
Most
agree.
people,
That's one of the bit. The way that it's written right now that most people don't understand is the worst part of sort of legislature.
yeah, I feel like most people can't engage really with the process because, I mean, people don't have the time to read some lengthy document. I feel like AI might make that easier to
Hopefully.
summarize these type of things for that. But then the danger in that is that the devil is in the detail often in these pieces of legislation where if you summarize an enormous bill, it's going to leave out certain details, and the devil is always in those details.
True. But then many of the bills are done for things like taxation, where they're really trying to add complex areas because of loopholes that shouldn't be there, because they've made things that are so complex, because they've made deals with people who they shouldn't be making deals with. Like this corporation had, we don't want to lose them from our state, so we're going to make a deal with them, and we're going to put that little tacked on side here. And
yeah, so
just simple taxation would get rid of 90% of those sort of laws.
Yeah, I agree. But I feel like there's a need for like a greater need for checks and balances, and it's going to be very difficult to try to get the legislative bodies to impose those types of checks and balances because they're exploiting essentially the power that they have, the centralized power that they have at the moment.
And I actually think the bureaucracy is probably the bigger problem, even than the legislature.
Yeah. But I see that I just have a general vision where we could put most of what's happening on chain and then create systems on top of the data that's on chain so that it's actually could be manageable for the average person, create systems that would actually make things more transparent and accountable. Do you see that as something we could do on Bitcoin or?
Yeah, definitely. Someone just needs to build it. So many things we need to build.
Right.
All right. I'm actually going to have to run, but thank you, everyone.
Thank you again, Craig, and we will talk soon.
No problem.
Thank you.
Right, I will just give a goodbye to the Twitter space as well. This was our first time trying this on Twitter. Yeah. And it seems to have gone well. So every month we will be linking in the Twitter space and trying to build up the class. If anyone wants the paper, I'm going to talk to Craig because he says chapter 6 isn't actually quite finished, which is the stud one we just done. You'll have to wait for that to see if I can make it more public or not. Otherwise, you can ask questions on Twitter and I will try and answer what I can. Otherwise, thank you very much, everyone. And next month, I will try and give some more warning in the Twitter space when we're going to do this, because doing the Twitter link thing was a bit of a spur of a moment thing, which I think has gone pretty well. So thank you very much, and thank you for our class in personal attendance again. Okay. Also, last note, this class is recorded and will be put on YouTube in around a week, maybe less. Okay, thank you, everyone. Talk to you soon.